Paul and Mike. I agree that there's still the potentiality to get justice through a federal or state grand jury in some matters. My question is when the state itself is a party in the action, as well as the other entities, then I'm not convinced that the prosecutorial and judicial influences on the grand jury can overcome the bias and conflicts of interest that are predicated by the perpetrators. That's my conundrum that I find here in this situation.
Well, if I may, it's the numbers that we could generate that could push it over the edge. That's the difference between the trial by jury and the grand jury. In the grand jury institution, we, the people, can push and bring attention to it. We could also engage our representatives to get involved. We could engage our military officers to get involved by enjoining to the petition and having them go in person. A state representative could walk right into the jury, into the grand jury office, and demand to be heard.
If I may, Michael.
I yield.
In answer to your question, what you need to understand is this. The Constitution of the United States provides you in the First Amendment all the need to walk up to the bailiff of a grand jury, state or local or federal, and request a conference with the foreman. And let that foreman, and then let that foreman know that you have a serious complaint that you want the grand jury to hear. And under their oath, state or federal, I don't care which you go to, they have an oath which commands them to diligently inquire and true presentment make of all such matters and things coming to their attention. So you, as an individual, have an absolute right to petition and be heard by your grand jury. Now, will you be opposed? Yes. For example, our current petition to the federal grand jury was short-stopped. It never reached the hand of the grand jury foreman or any of the grand jurors. They, till this day, do not know that we are standing at their door knocking. And why is that? Because the United States Attorney and the employees in his office stopped our petition from reaching them. They, the United States Attorney, the United States Department of Justice, is guilty of violating our civil rights. Those are criminal statutes in federal law.
Hear, hear.
So what we have to do is to make this matter known. How do you do that? Well, you hire an attorney, you go into federal district court, and you name the grand jury, even though they are absolutely innocent. You name the grand jury as an essential party to your mandamus. Or you subpoena them as witnesses. Now, all of a sudden, they're going to find out, hey, our neighbors have been down there knocking at our door for months, and nobody told us they were there. Now the grand jury is going to get ill. When they find out their neighbors were abused by the very people who were sworn to protect them, to let the grand jury know we are there. All United States attorneys have the commandment from the United States Congress in 18 U.S.C. 3332 to inform the grand jury anytime a person demands that their complaint be heard by the grand jury, and they're refusing to comply with their oath of office. Now, that's another felony. In Georgia, that'll get them 5 years in a state penitentiary. But we've got to have the attorney. We've got to have the sad fact of life is it takes money to hire lawyers. And that's what we're trying to do right now, is to raise the money necessary to hire an attorney who is capable of bringing this matter into the light of a courtroom proceeding.